Hello and welcome to today's episode of Crystalcast. My name is Ross and I'm an immigration lawyer based in Sydney. I hope you've all had a good week. Today we've got quite a bit to cover. What I'm going to talk about is give you an overview of what's been happening in immigration. Quite a lot to cover in terms of the state invitation rounds, ENS changes and more. Our topic of the week this week is public interest criteria PIC 4020, and it's those tricky cases where it helps to understand the difference between incorrect or false information and also bogus documents. Now, this week we do have a special guest, Evan Bishop. I'm looking forward to our chat in relation to the ENS changes. Evan is very well known in the industry as the employment visa specialist, and we sat down earlier this week to talk about the latest immigration changes and how that impacts both applicants and also the employers. Thank you very much for tuning in. If you like the content that you're hearing, please ensure that you like and subscribe to our channel so that we can continue to provide this podcast to you free of charge and on a weekly basis. And we only have 2 episodes left this year. It has flown by very, very quick. So I do want to say that it's been excellent and I've had a lot of fun recording this podcast and still am having a lot of fun recording this podcast. So I'm looking forward to you enjoying this episode and our final 2 episodes before 2023 wraps up. Sit back, relax, and enjoy this week's episode of Crystalcast. And now moving on to our second segment, which is immigration news in 5 minutes. Now, what we're seeing at the moment is that a number of skills assessing authorities are wrapping up for 2023. And therefore, if you are lodging skills assessments, it is important that you lodge your application as soon as possible. So, for example, there was a notice from VetAssess. VetAssess will suspend lodgements of priority processing applications on Sunday, the 10th of December, and will resume on Monday, the 8th of January, as VetAssess returns back from summer break. This means that the last day for priority processing applications will be the Sunday, 10th of December. This will ensure that all priority processing applications lodged in December are approved as eligible for service, can be completed in 10 business days before holiday break. Now, VetAssess has confirmed that they will continue to assess standard applications as per the normal processing times. But again, keep in mind that these processing times may be a little bit lengthy, given that there will be no assessing officers on duty. We have also received newsletters from other skills assessing bodies, more or less hinting at the fact that there will be less staff available to assess applications. We are now at the start of December, so really this is a good opportunity to start wrapping up, whether that's your skills assessment, whether that's your visa application. I know that a lot of providers will be going on a holiday break. Our firm is closing for the holiday period from the 22nd of December. So it is a busy month, I think, for everyone. But if you do get in your applications early, whether that's a visa, a skills assessment, or any other type of application, I'm pretty sure you would be able to get this processed. In terms of other news, we have discussed the implementation of permanent residency for sponsored employees. Now, off the back of that, there was also an instrument released in relation to COVID-19 concessions. So just to give a bit of background as to what COVID-19 concessions are, essentially a number of visa applicants during the COVID period, which is 1 February 2020 until 19th of February 2021, were impacted in a way where they couldn't get back into the country, couldn't continue studies, and had other issues that were happening. So because of that, the government has introduced blanket COVID concessions to ensure that these individuals didn't miss out on eligibility for their subsequent visas. So for example, certain visas such as 485 visas could be granted offshore. Period of non-employment could be considered as period of full-time employment if you can demonstrate that there was a direct correlation to COVID-19 disruption. Now, at the end of November, the new instrument was released confirming that the COVID concessions have now been made redundant, and that really came as a way of introducing other instruments which basically allowed individuals to continue to apply for visas in a standard manner, or perhaps even make better arrangements, so therefore making COVID-19 concessions what I would say is redundant. Since early 2020, the global impact of COVID-19 pandemic led to international travel restrictions and challenging economic and employment conditions. In response, the previous government introduced temporary measures during an initial concession period, offering relief to applicants of specific visa subclasses affected by travel constraints and facing difficulties in meeting visa requirements, particularly in terms of applicant location at the time of application. So this would refer more to the applicant being outside Australia when really they should have been in Australia for lodgement. With the removal of all COVID-19 international travel restrictions, travellers to Australia are no longer required to provide information about their vaccination status or seek travel exemptions, and thank goodness for that. The cessation of the concession period is aimed at contributing to a well-managed migration system, ensuring that unintended cohorts do have access to concessions. Affected visa programs utilising the initial concessions include the ENS, or the Employee Nomination Scheme, and RSMS. So effective from 25th of November, around 13 days ago, the new nominations for these visas will necessitate the temporary skill shortage visas who worked with their sponsoring employer to transition towards PR after working with their employer for 2 out of 3 years on the eligible visa. In addition to that, various COVID concessions relating to work experience age exemption and legacy workers will become obsolete. For example, reduced period during COVID-19 will no longer count towards meeting the work experience requirement. And again, the reason for that is because these concessions were meant to be temporary, and the government has made it very clear that these concessions will come to an end. But I do want to reassure the listeners that what we have in return is much better, because we no longer have concessions that people can rely on, given that COVID is now further and further away. Most people won't qualify for any of these exemptions. So we've now gone back to the pre-COVID days, but also, I suppose, with better perks such as all occupations being able to transition towards PR. Legacy workers, the 457 workers, will continue to apply or will be able to access ENS and RSMS until 1 July 2024. The skilled regional visa subclass 887 will see the end of the temporary concessions affecting eligible applicants' ability to lodge from inside or outside Australia during the concession period and access shorter employment and regional residence requirements. For family visas, COVID-19 concessions lift the restrictions on the location at the time of visa grant. Those applied before 26th of November 2023 and were in Australia during the concession period may still be eligible for visa grants in Australia after the concession period, provided they meet other criteria for the visa. However, concessions will not apply to applicants who are not in Australia during the COVID-19 concession period. And in relation to the graduate visas, starting from 25th of November 2023, all applicants in any stream for the temporary skilled graduate visa program must be lodged in Australia, while subsequent entrant visas for dependents can be lodged either in or outside Australia. Now, on to GSM news. We saw the closure of GSM program for Northern Territory. So we did report earlier on in our sort of one of the few first episodes that Northern Territory has closed the 190 program and continued with the 491 program. Now both the 491 and the 190 program has been closed. Northern Territory will continue to advocate for more allocations and is hoping to resume invites in July 2024. And last but not least, the ACT held an invitation round on the 27th of November 2023. ACT has a fixed number of nomination places available for each month, pro rata against annual allocation. The highest ranked matrix in each of the occupations were invited to apply for the ACT occupations. So just to give you a bit of idea of who applied, in the SBO or small business owner stream, there was one invitation for 190. The maximum matrix score was 125. 491 received 3 invitations in the same stream with a minimum score of 95. The 482 visa holders, 7 invitations for 190 and 1 invitation for 491. Critical skilled occupations, 190 saw 61 invitations. 491 saw 46 occupations or invitations. And interestingly enough, there were 0 invitations issued for overseas applicants. Now on to topic of the week, which is public interest criteria. If you are a migration professional, you're probably familiar with what is public interest criteria. If you are someone who has applied for a visa or thinking of applying for a visa, well, public interest criteria essentially requires you to meet a number of elements, and whether that's health, whether that's character. Specifically, what we're going to talk today about is public interest criteria PIC 4020. So PIC 4020 refers to certain information that you provide to the Department of Home Affairs as part of your visa application. Now, that statement can further be broken down to what sort of documents you provide, what sort of information you provide, and also whether you are able to prove your identity. For example, if I provide a copy of a passport which is fraudulent and claim that I'm someone else, that would be caught under PIC 4020, and that carries the harshest penalty because the re-entry ban, should the application be refused on the identity requirement, is 10 years. Now, unlike the other PIC 4020 provisions, there are no compelling, compassionate reasons that a case officer can legally exercise in order to grant a subsequent visa. So it is important to, the good news is you're not going to have many applicants that are going to go down this pathway. At the end of the day, identity theft is probably one of the most serious crimes that one could commit, especially when it comes to migration, because you've got a visa grant, you're getting a visa against someone's name. So therefore, I don't believe, or at least I haven't seen in 15 years, many people attempting to do that. Not that I'm saying that it doesn't happen. That's just been by experience, but nonetheless, it's important to know that it's there. Now, the second part of the public interest criteria is providing a false document, or what's called a bogus document. So for example, if a letter of employment is falsified, or perhaps an English language test is falsified, that would be classified as a bogus document. Now, the problem with the bogus document is that the Department of Home Affairs doesn't need to prove whether the document is relevant to the assessment of the application. So say, for example, if you provide a copy of an IELTS test certificate for an application that doesn't require an English language to be demonstrated, the fact that you've provided a false document, that it is in itself sufficient to trigger PIC 4020, and therefore the visa must either be refused, withdrawn, or if there are any compelling, compassionate circumstances to grant the visa, those will need to be exercised. And the third part, which is probably the most common one, and that is false and misleading information. Now, there is a difference between false and misleading information. So, for example, if I say that I've never worked in immigration, well, that would be false information. If I said that work in immigration, but I didn't specify whether that work is full-time or part-time, and that's relevant to the assessment of my overall experience, and that's relevant to the visa assessment. Well, that would be deemed as misleading information, because you're not necessarily telling a lie, so you're not providing false information, but the information is construed in a way that helps to assist you. The most important thing to do is, if you do receive a letter from the Department of Home Affairs saying that there is false or misleading information, it's important not to assume that there is false and misleading information. Sometimes, and I've assisted a number of visa applicants and also practitioners in terms of counsel in regards to PIC 4020, and it's important to understand that the Department of Home Affairs or the delegate needs to establish three things: that the information was, or false or misleading information was given or caused to be given. So whether that's given by you or a migration agent or immigration lawyer, the information is relevant to the assessment of the current visa, or the information was relevant to the visa application made in the last 12 months. So the onus is on the Department of Home Affairs to demonstrate that, and if all three elements can't be proven, then there's no PIC 4020. And it happens to be sometimes that whilst on face value, the document, the information may appear to be misleading. However, when you look at the facts and the contextual nature of the situation, the story may be different. So, for example, we had a situation where the department came back and said that the information contained in the employment reference letter was false or misleading. Now, how that came about? Well, when the case officer has contacted the applicant's company, they've actually called just the general line as opposed to calling the person who provided the reference. So go figure. And the person who answered the phone did not know the applicant, because they were not in a position to provide the reference, and therefore provided just some of the generic tasks that someone in this company would do as part of their role. So it does happen, and I think the most important thing to do is to seek professional advice. And the reason why that's important is because if you don't get to the bottom of what's happened, the ramifications are that not only will you get a refusal, you will also get barred, or you may get barred from re-entering Australia, and that can have quite serious consequences. So, and we've also seen situations where, for whatever reason, the information that has been provided is indeed incorrect, or false or misleading, and that needs to be rectified as well. So therefore, if you do receive a PIC 4020 letter from the Department of Home Affairs, before doing anything, make sure that you do speak with a professional to understand what can be done, and whether something can be done to avoid that 3-year re-entry ban. Now, our next guest needs no introduction. I was lucky enough to sit down with Evan Bishop, who is well known in the industry as the employment visa specialist. Evan is the go-to person when it comes to training visas, subclass 494s, 482s, and ENS changes. Evan and I sat down and talked about the implications that the new instrument had in relation to permanent residency, and also just some of the practical tips and common misunderstandings. And we've talked about how one could assist both employers and also visa applicants in order to embrace these changes and also apply them effectively. And here's my interview with Evan.
Sound okay to you?
Yep, you sound perfect. So let's get started. Alrighty, on this week's episode, we're lucky to have Evan Bishop, who is known as the Employer Visa Specialist. Evan, thank you so much for being on this week's podcast. Perhaps before we get started, tell us a little bit about yourself, what you do, and your passion for employment visas.
Yeah, thank you, Ross. Look, I run my own agency called Worthy Migration. My background was in recruitment and HR advisory. So we're looking, 10 to 12 years ago, I was doing training plans for a lot of big 10 accounting firms and a lot of the big IT companies and big engineering firms. And I was also doing a lot of labour market testing when that got introduced, and annual market salary rate in my capacity as a recruiter. So we're talking November 2023, so almost 10 years to the month. So, that was November, 2013. So, so 10 years ago, that gave me an insight to migration law. I wanted to find out more, and that's when I became a registered migration agent thereafter. So I've always been within the employer-sponsored visas, and my love for them is because no two circumstances are the same, but you get to learn about different industries and sectors and particular occupations as well. So that's definitely my background, and I'm also a presenter with yourself at Crystal Migration Training, so it's a great opportunity for me to convey my passion and me to have an outlet to convey that to people on a weekly basis when they're getting their CPD points, but to be able to educate others as well, to gain some confidence and to upskill yourself into taking on these visas, because these visas are never going anywhere. We see it's very cyclic with the general skilled migration. At the moment, we're sort of in an era of the sort of sprint short invitation rounds. We had a period there where there was lots of invitations, and of course, during the peak of the pandemic, we had a period where there was little to none invitations. So employer-sponsored visas will always exist. There'll always be a need for an Australian tax-paying employer. They've got a skilled shortage, and they're going to have the vessel of sponsorship to allow a migrant worker to fill that skilled gap. But we're in a very good era at the moment where there's more opportunities for temporary migrants on employer-sponsored visas to have a pathway to PR.
Yeah, exactly. And I think I wanted to have this conversation with you because we both share that passion for employment visas. I've been doing immigration for a number of years, and employer-sponsored visas have really stuck with me. And I completely agree with you. It is very cyclical. And I suppose when the TSS visa was introduced, the purpose for introducing the TSS visa versus what we have now, the goalposts have shifted. We had the COVID-19 pandemic, and we just had an array of instruments that were released where particular candidates would be eligible, others wouldn't be. So I suppose a very big thing happened on the 25th of November where the government has released an instrument and also regulations to go with that to essentially say that the temporary residence transition pathway would be open to more cohorts. And this is what I wanted to talk to you about because personally I'm getting a lot of inquiries in relation to not necessarily the more cohorts, but just getting individuals who may work for an employer, but not necessarily on a sponsored visa, and they may not necessarily qualify. What's your experience been like? What are the sort of common questions that you get in relation to ineligibility for the temporary residence transition stream?
Yeah, there's a lot of excitement out there because the average punter out there who's looking at gaining permanent residency for themselves, they hear what they want to hear, and they look at the website and they see, okay, all 482 visa holders will have access to transition to permanent residency. They see the words 482 and they see the words permanent residency. So really the changes have simplified the process instead of breaking it into the streams and looking at, okay, certain cohorts can apply to PR or to transition to PR, others can't. If you were working during the bulk of the pandemic for a 12-month window between these dates on a short-term stream, regional stream, you can transition. It really broke down and simplified it. So therefore, you can get some confusion out there, and it's really around two particular areas. You get the short-term stream visa holders, which effectively is almost half of the skilled occupations list.
Yeah,
and
definitely.
they're on a 482 visa, and they hear that now all 482 visa holders can transition to permanent residency, which is correct. And understandably, they're itching to get their PR as soon as possible. They think, well, does that mean I can now apply for the 186 direct entry stream? And they want to go straight to permanent residency. They say, look, I've got my 3 years of experience. I'm under 45. I've got my competent English. They look at all the eligibility. But the 186 direct entry visa has not changed. It is still the same eligibility criteria and only limited to those on the medium to long-term stream occupations. So That hasn't changed. What has changed is the pathway to permanent residency for all 482 visa holders, not just limited to the medium to long-term stream, or those who were eligible for a COVID concession. So it has simplified it in that regards, but it doesn't mean that you can go straight to direct entry in a lot of circumstances, still only limited to the medium to long-term stream. And probably the other main misconception out there, and I believe it was yourself that mentioned on the Department of Home Affairs website, it mentions that all occupations can transition to the 186 transition stream. So the black and white answer is yes, that's correct. But what is the eligibility for the 186 transition stream? You've been a holder on
qualifying visa.
You've been a holder of a 457 or a 482 for what's now been reduced to 2 years instead of 3 years in the nominated position to then have it's a privilege, not a right, to have that opportunity to apply for permanent residency. So if you do read that without looking into the deeper eligibility criteria, you just think, oh, fantastic. Well, any occupation can transition to permanent residency. Yes, that's correct. But who can achieve that 482 visa in the first place? That's where we fall onto only the skilled occupations list.
100%, and I've got to agree with you there as well. I think the easiest way to explain it, and you've articulated it so well, the actual eligibility criteria for the temporary residence transition stream has not changed. So what we have seen is a reduction of the work period. So that's gone down to 2 years, and also the COVID concessions have now been removed. And there's been a couple of exemptions added in relation to age and things like that. But it's not one for all, where basically if the occupation is listed on the ANSCO, you can apply for the transition stream. So to me, that is the biggest misconception. And I think it's important to understand that, and look, it happens quite a lot, unfortunately, where the Department of Home Affairs does provide broad information. And as you've said correctly, sometimes, if we don't specialize in a particular area, we sort of pick bits and pieces and we make it fit with our story, so to speak. And that can be a bit of a sort of unsafe way of doing things. And you could end up in a situation where you're lodging an application, but you don't meet the criteria in order to actually fit within that cohort.
And I almost feel horrible for having this thought, but because the Home Affairs website cannot be all-encompassing, it is a basic landing page for informative purposes. It's great for business for us because it can't contain everything in there. Now, if it was the opposite and the Department of Home Affairs website was the legislation and it allowed people the tools to learn how to read legislation and all that side of things, it wouldn't look like the informative website it is today. So, like I said, I feel bad having that thought, but it allows professionals like you and I to help people navigate where do they fall within these circumstances. What is suitable to their friend or their family member who went through and got permanent residency through one way may not be suitable for themselves. There is no copy-paste approach.
Yeah, it's interesting that you mentioned that as well, because that's the other thing that I get quite often. So, for example, even say a sponsor might come to me and say, well, Joe Blogs, they went through a particular process. That's what they did. So how come we can't put, this particular individual under the same circumstances? So the Department of Home Affairs website, and again, I think it's a great sort of primary source, but it will give you that basic information. So it's important to not compare your circumstances. I always like to compare this to filing taxes. So, for example, me putting forward my BAS statements, my company reports, it's going to look different to the person next to me. I can't rely on what the person's done next to me in order to sort of rely on that assumption that everything will be correct.
Of course. And I even take that a step further and you look at your tax returns. And if you did it individually yourself, you might get a $50 return, but if you went through a taxation agent, you might get a $500 return. So when it comes to your visas, it effectively is non-discretionary spending. So as the employer,
I agree.
Do you want to spend these upfront costs to retain the existing member or to onboard a new member? And for the visa applicant, do you want to stay in Australia or not? So it is non-discretionary discretionary spending all up front at the time of application. If you get it wrong, you didn't take that time and the care to check not only your eligibility, so yes, by all means, you can lodge a valid application, but does it have strong, sound chances of success as well? So you'll only find that after the fact, and yeah, hence why it's worth getting that tailored advice.
And thank you so much for being on our podcast this week. And I look forward to many, many more presentations that we'll have by you at Crystal Training. Thank you so much.
Thank you for the invite. Cheers. Have a good day.
Yes. And that's all that we have time for this week on our episode of Crystal Cast. Once again, thank you very much for joining us today and supporting us throughout the last 14 episodes. It certainly has been a pleasure delivering this podcast every week and continue to deliver this podcast on a weekly basis and provide you with news, information, and other relevant matters that fit into the world of immigration, whether that's on visas or related matters. If you have any questions at all or any comments, please feel free to leave them in the comment section below. Make sure that you like and subscribe to our channel, and we look forward to seeing you next week. Same place, same time. Have a good weekend.